Welcome and thank you for standing by. At this time, all participants are in a listen-only mode until the question and answer session of today's call. At that time, if you'd like to ask a question, please press star one. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I would now like to turn the meeting over to Melissa Grasso. Thank you, and you may begin.
Great. Thank you so much, and good afternoon to everyone. Good morning to those on the West Coast. We're happy to have our second of 17 webinars. Today's webinar is complying with the International Traffic in Arms Regulations. For those of you who were with us on Tuesday, you heard a good amount about BIS and the scope and jurisdiction of the EAR and of commerce. Today we're going to dive into State Department's ITAR rules, so we're excited to have you with us. For those of you who are not with us on Tuesday, I just wanted to give a quick plug to the U.S. Commercial Service, which is the trade promotion arm of the U.S. Department of Commerce. So essentially we work with U.S. businesses to help them to strategize and execute international business plans. You can find your local office at www.export.gov. We have offices throughout the United States and in about 75 countries overseas at U.S. embassies and consulates. So we're a great business tool for you to utilize, so I encourage you all to connect with your local offices. Again, another reminder that we do have 15 additional webinars taking place between now and the end of August. This is just a little overview of some of those webinars. You can go to legalaspectsoftrade.com and you can see the full listing and details of all of our future webinars. And with that, I'd like to make a quick introduction and express our gratitude to our speaker for today, Alfredo Fernandez, who's an associate with Shipman and Goodwin, LLP. Alfredo focuses his practice on international trade compliance and enforcement issues, and he works with companies in matters involving ITAR, again, the topic of today's webinar, as well as the Export Administration regulations and other related U.S. laws and regulations. Prior to joining Shipman and Goodwin, Alfredo worked as an aerospace engineer for one of the leading aircraft engine manufacturers. So he brings with him a good technical knowledge of various products. So with that, Alfredo, I will turn it over to you.
Thank you, Melissa. Good morning and afternoon, depending on your time zone. I'm just going to move these slides up to where we begin here. Melissa, it looks like the...
I am back on yours, Alfredo, so you should be good to go.
Now we are good. As Melissa mentioned, I'm Alfredo Fernandez. I'm an attorney at Shipman and Goodwin, based in Hartford. The firm has offices all throughout Connecticut, New York City, D.C. And with this kind of practice specifically, and with others, it's a national and international practice inherently, so clients all over the country and the world dealing with complicated international trade issues coming from both sides of any given border. So I'm going to present a little bit of the next hour or so you know what's coming down in the presentation. And as Melissa mentioned, this is only session number 2 of a pretty lengthy and robust series with a variety of speakers over the course of the summer. So this one by design is relatively beginner level, an introduction to the ITAR, some of the key concepts, and as the series goes on, some of the topics will become more narrow and more detailed and more specific. So we're going to start at the high level with the ITAR, just like some of you may have seen with the EAR a few days ago. We're going to explain what the ITAR is, what the ITAR covers, what it does not, how to comply with the various registration requirements, licensing, how to get out of a license when it's appropriate, and then when things go right, that's perfect. It's good for business. When things go wrong, there are options for you to evaluate, such as a voluntary disclosure, and you may have to deal with some enforcement and penalty side of this business if things don't go wrong, emphasizing the need for a strong compliance program, which brings us to that last agenda point, is what the State Department expects out of your compliance program. And it can vary depending on the size of your operation, whether you're a one-facility shop with 20 employees or a multi-state, multi-facility type business, or one of the the much bigger OEMs that sometimes have a staff just dedicated to international trade controls, the expectation from the government will vary, but we'll get into a little bit of the essential concepts of the compliance program towards the end. In terms of Q&A, you can save your questions for the end, type them in the little box, and we'll address them as we go. Or we have the voice option that will be opened up to everybody later. So we'll keep moving. Wanted to start this out and may have a little bit overlap with the EAR presentation right at the beginning, but we'll get into ITAR-specific concepts in a bit. There are varying purposes for export controls generally, especially with items subject to the ITAR. There is a military concern and U.S. national security. It's not very shocking to know we want to keep some of our more sensitive military technology and items in the right hands, whether the U.S. or allies. It can be a foreign policy tool, playing nice with countries that behave how we like, playing mean with countries that we don't particularly like what we're seeing. And again, it's all part of the negotiation with treaties and the global commerce dynamic. And then in certain situations, certain countries that are war-torn and really have some human rights issues, emphasizing the security of their citizens where we can is another flavor of why we have our own export controls, especially with guns and ammunition. And then lastly and importantly is for the economic protection of our own U.S. national economy and making sure U.S. businesses can compete on a global level, which may or may not contradict some of the national security issues themselves. So always an interesting dynamic in all those purposes and all those goals, and they don't always line up perfectly, but always in play one way or the other. That was a general overview, including the EAR, including ITAR, including other federal agency things like agriculture and EPA and a variety of Department of Energy type export control regimes, some that are very, very specific. But the general products are under the EAR and the ITAR for defense articles specifically, and we'll get into plenty of detail on what that means in a bit. But at the basic level, the ITAR controls military items and technology. Administratively, this is enforced by the Department of State and specifically under there, the Directorate of Defense Trade Controls, or as I may refer to it, DDTC. There are some other smaller departments within DDTC and the Department of State that have specific roles in the export control and the enforcement of the ITAR, but for purposes of this presentation, DDTC is the main player. Statutorily, these regulations come to you courtesy of the Arms Export Control Act, which is a federal statute. Specifically, though, what you're going to be reading when you need to look at the ITAR, or the International Traffic in Arms Regulations, if I hadn't spelled that out yet, is at 22 CFR Parts 128 to 130. That's the Code of Federal Regulations. A little Law School 101, the regulations are implemented by the Arms Export Control Act, but they are, in effect, the military export rules. So I mentioned the ITAR controls, the defense items and defense technology. So we're going to get into a little of the meat here of what is a defense article and why is it covered under the ITAR. So as you can see on slide 7 here, a defense article is something that's listed on what's called the United States Munitions List, or the USML. That is the easiest way to define it, and the bulk of what is covered by the ITAR. There's a list of over 20 categories broken into aircraft, gas turbine engines, chemicals, ground vehicles, weapons, space issues. and you get the picture. A different category all throughout the USML. So if you are dealing with defense articles, you should absolutely know which USML category and subcategory you fall under, so that can tell you the rules of what that means. And for documentation, you're going to need to stamp that on a few of your items. In addition to what's actually on the list, if something performs equivalently to something on the list, even if it's not explicitly on there, it can be covered by the ITAR if it's considered a defense article. And the State Department reserves the right to later add something if it's an item or technology that provides a critical military advantage, even if it's not on the USML and even if it's not a performance equivalent. So those are the three categories of what will catch something as a defense article. And as the last bullet shows, it can be the physical form, but also unfinished products like forgings and castings, or some kind of physical negative of the part that would be made. So it can expand quite a bit as to what a defense article is. And if I wasn't clear before, the defense articles are usually physical things that you can pick up or touch, or they exist in physical space. The technical data, on the other hand, is information. It doesn't have a tangible form, but it is obviously quite useful, and in some cases, in some industries, the only product really that you might make. That includes software and design specs and things like that. So that is, you can imagine, you're not putting it in a box all the time and stamping it and sending it off to a different country. You're sending it, you're transmitting it, you're speaking it, and we'll get into the details of how technical data moves and what is considered an export, which may make your head spin if this is the first time you're hearing it. But generally speaking, the definition of technical data in the ITAR is information that's required for the design, development, production, etc. That whole list of actions that's on the slide there for you. There's a couple extra little bullets that are pretty narrow in scope if you feel like going to the Code of Federal Regulations at section 120.10 for the full definition. But for most people, this will cover what the idea of technical data is. If you were on the EAR webinar the other day, you probably heard the term technology, which is a similar yet distinct concept. There's a different definition of technology under the EAR, and it's a little bit of nomenclature back and forth. There's technical data under the ITAR, there's technology under the EAR. They're more or less the same with some very minor differences. So if you are dealing with both sets of regulations, you want to make sure you're appreciating the nuances between the two definitions. And lastly, defense services are covered by the ITAR. And this is a little different than technical data and a little different than defense articles. This is you assisting, or you as a U.S. person or U.S. company, assisting foreign persons, doesn't matter where, in stateside or overseas, in the design, development, etc., on how to process, manufacture, use defense articles. So basically a lot of training, technical training, or military-type combat training, all that stuff would be considered a defense service. So it's actually a relatively broad definition, but it's not super applicable to a lot of businesses that are just making a product for the aerospace or defense or naval-type supply chain. So it's a definition to be aware of, especially when in the training aspect, and just because not that many people do actual military-type training for troops, that element of the definition doesn't get a lot of play in terms of numbers of companies. All right, so what is an export? We've agreed that the ITAR controls exports of defense articles. We've kind of defined already what the defense articles include, what defense services include, what technical data includes. So now we just know we can't export it, but we haven't discussed what exporting means. So it can mean a lot of things, and probably too many things. First off, the easiest one to conceptualize is the actual shipment or transmission of a physical commodity from the United States outside of the United States. You put something in a box, you send it to your customer in Germany, that's an export. Whether you needed a license for it or not is a question we can address later, but it depends really on what you're sending. But that one's easy to get. In addition to that, releasing or transferring technical data to a foreign person while you're in the United States is also considered an export, even though there's no cross-border movement and you're just having a conversation or sliding a piece of paper across the table, whether innocently or not. That kind of exchange or release, as the term uses, can be an export, and it's deemed to be an export to that person's country. So I got definitions within definitions, but that's the world of federal regulations. So we see release in that definition of a deemed export. Release means inspection by a foreign person enough where it's revealing some kind of technical data. So seeing something flash across the screen in a half second with a foreign national in the room probably will not count as an accidental export if you're giving a presentation, if they didn't have time to reveal technical data. If they're alone in a room for 10 minutes with a slide, then maybe that's a different analysis, right? Figuring out what the revelation of technical data to a foreign person means would be a fact-specific type scenario. And lastly, with the defense services, performing the defense service in the United States or anywhere in the world also counts as an export. So, like I said, it's a little bit of a recap, but we're going to blow out a couple examples that you might see in the real world. The items can include the commodities, the physical products you make, software that goes along with it, the drawings and specs and technical assistance documents, kind of the instructions on how to build. That kind of stuff is considered an item. It can go, like I said, in a box, email, face-to-face conversation, website, a WebEx like this. If I was presenting something and ITAR controlled data was on the next slide, that would be an export to wherever you physically are and to whatever country or nationality you are as well. So that's an easy way to connect globally with people all over the place, but you have to be careful what goes on there, even if they won't have access to the file after this webinar is done or that particular presentation. And lastly, we see a lot of enforcement in this area for whatever reason, people carrying devices with ITAR-controlled data in them, whether accessible through email or on a hard drive of a laptop type thing. And it gives companies a heck of a headache on worrying about what the devices will look like when they have to send somebody overseas. Just a little bit more definition for purposes of this, because we get a lot of questions on dual citizens and things like that working at your particular facilities in the United States. U.S. person includes citizens and legal permanent residents, or LPRs or green card holders. They are a U.S. person. You can give them ITAR-controlled technical data, even if they have citizenship in another country. U.S. corporate entities, branch offices of U.S. corporations, even if in foreign countries, if they're not incorporated in the foreign country, they're still a U.S. person, meaning that they have to be compliant with the ITAR. And usually any U.S. government entity will be considered a U.S. person. Foreign persons are those that are not citizens, not legal permanent residents, and then there are some refugee status exceptions for someone that could be a U.S. person if they're they're a refugee in this country, but there are some specific requirements to get there, and we don't see it come into play all that much just because there aren't that many individuals that qualify. And then any foreign company, the company that's incorporated outside of the United States or organized outside of the United States, would be considered a foreign person, and their employees are also considered foreign persons. All right. So I do want to expand, now that we understand what the U.S. person and foreign person definitions are, expand on the deemed export rule, because it is a very popular topic, a very vulnerable place in terms of compliance and monitoring and training your people. So we're going to spend a slide or two on this one. It is the transfer of technology to non-U.S. persons who are physically located in the United States that I mentioned before. In terms of specifics now, we're looking at employees of your companies that are foreign persons, visitors, customers, potential funders, partners, vendors, service providers, name it. Anyone that walks through your front door could be a foreign person, and their access or the release of technical data to them would be an export. Their ultimate country would be a different question, whether a license is required or some kind of exemption applies. But usually for the ITAR, a license is required for EAR type information, not necessarily as strict in terms of licensing. So given the sensitivities, you have an important customer coming in, their CEO, CFO, chief engineer wants to come through. I acknowledge that it can be difficult to do a little extra paperwork, but you want to evaluate how much of your process you want to enhance to make sure there's no inadvertent and unauthorized exports of ITAR-controlled technical data.
And Alfredo, if I could interject with a quick question that's come in over the queue on this definition. The question is, if a U.S. citizen is working for a foreign entity, can you not give that ITAR product or information to the U.S. citizen?
That is correct, that you cannot. When a U.S. person is working for a foreign company, they are considered a foreign person for purposes of the ITAR. Doesn't mean you can't ultimately get them something, but you would have to go through the licensing process, assuming a license would be required, which is a generally safe assumption for the ITAR. Say they're working for a UK entity, but they're still either located in the US physically or in the UK or any other country. You'd have to, if the technology you're trying to provide them would require a license to the nationality of their employer, you would have to go through the licensing process, explain what it is. It would probably help your case that the person is a U.S. citizen that just happens to work for a foreign company, but the State Department would expect to know the circumstances as part of their regular licensing procedure. I hope that answers the question, and feel free to type in a follow-up if needed. So continuing with the deemed export rule, not only is the citizenship of that particular foreign person implicated, but also if they hold permanent residency in another country, with the ITAR specifically, you're going to be considered to have exported to both those particular countries. So a UK permanent resident who is technically an Indian citizen in the United States on a business trip, if he or she receives technical data that is subject to the ITAR that would have required a license to either of those countries, it could be an unauthorized export, and not just to one country, but for the ITAR, actually both countries with the same release of technical data. The EAR is a little different. They're worried more about the actual citizenship. and I would have to point you to the right definition there if needed. Let's see. Okay. And like I said, again, this figuring out this deemed export thing, it can be very challenging with your employees, guests, and anyone coming into your physical space, as well as your digital space or your electronic file system. And in cases where you're employing a foreign person and going through the visa process for them, there is a box that maybe you had not given it much thought, but that you're certifying that you're compliant with both the ITAR and the EAR for the non-U.S. person you'd be bringing in. So we get a lot of questions on when people are filling out that form, they see ITAR and EAR on it and get nervous for an applicant that they're trying to bring in for a work visa, and we'll step through the job scope, figure out what controls are appropriate, so then they can feel comfortable checking the right box on the visa paperwork. All right, the next definition that does come into play quite a bit for a lot of our clients is a re-export. And really this is just an export that goes from one foreign country to another. So you mail something to France, someone else mails it from France to Italy. That France to Italy leg of the transaction is considered a re-export. There are some controls on re-exports, and as the U.S. exporter, you should be aware of anticipated re-exports in terms of end use and end user, and it's probably a requirement to figure out where it's ultimately going to end up in terms of what you're putting in your license application. And if there's a re-export that's definitely happening once you send it to your foreign country, the State Department licensing group would want to know that. I would expect to know that, and the absence of that information could be a compliance issue. All right, I do want to just distinguish this re-export definition from yet another definition called the retransfer. And the retransfer is just a change of ownership or end user or end use within the same country. So there's no country change. You send something to your customer in France, they transfer ownership to the piece to another company within France, and assuming everybody's a French citizen, that transaction there would be considered a retransfer because it's really not an export or a re-export. Definitionally, there are also some controls, and for licenses, the licensing officer would want to know if there's a retransfer that would be happening, just to make sure all the parties involved are above board. And now we start just smashing definitions together. We're going to get the deemed export and the re-export, get married and create what's called the deemed re-export. And without going word by word here, it's really just releasing technology to a foreign person in another foreign country that's not their own citizenship type country. So you can see how these just start matching together and making a somewhat complicated mess of what the transaction could look like outside of the United States as well, both in terms of physical movement and technology and technical data releases. So these are very important to have a grasp of before you send your product outside the United States, because there could be licensing requirements ahead of time. And that's really the point of a lot of these definitional slides we should get out of the way as part of the introduction. But I think we are done now. So in terms of things you have to give the State Department, if you are an exporter, I'll get that on the next slide in more detail, an exporter of defense articles or a manufacturer of defense articles, you will have to register with DDTC and kind of get in their system. The next slide will cover more details there. What else do you have to send to the State Department? When you have an export license application, you gotta send it in somewhere. It's all electronic now. You got to log in, create your user profiles, and submit the license application. The back and forth with the licensing officer is usually done online and with phone calls for supplementary information. If you're trying to submit a manufacturing license agreement or a technical assistance agreement, those kind of applications are also done online. You have to send that into DDTC so they can review and comment. And then in the unfortunate situation, you have to make a disclosure, whether voluntary or not. You know, that's something you can either mail in but it would be a required submission. The manufacturing license agreement, I'm just going to hit briefly because I didn't put in individual slides for these to kind of keep it as light as I could for the introductory piece. But this is an agreement between a U.S. company and one or more foreign or domestic companies laying out the business plan for a particular business arrangement. It's going to go from A to B. They're going to do some welding, and it's going to go from B to C. They're going to do a powder coating, and it's going to come back to A. And rather than doing an ITAR license every time, you have a manufacturing license agreement, or I'm going to send them materials, they're going to make me my part, and then send it right to the customer. You know, that can be a complicated paperwork process without the agreement, but once the agreement's approved by state, it's a little bit of upfront work, but in the long term, it should ease the process. Similarly, with the technical assistance agreement, if you're consulting with a foreign technical specialist or a company or an outsourcing engineering group or even your own non-U.S. subsidiary, rather than every transmission or email or phone call being requiring a license, getting a TAA in place with all the details is kind of a blanket license for a particular project. So those are a little heavy to get off the ground, but once they're moving, quite useful depending on scale. So in particular, the registration requirements that I mentioned as the first bullet on the last slide, any manufacturer, exporter, or broker of ITAR-controlled products has to register with the DDTC. It's not that heavy of a lift. It's a little moderate fee, and it's valid for a year. You know, I'm not going to get into the details there because I assume most people on this webinar probably already did that step. But the link is on there if you want to go check it out, you got to go through it for the first time or renew, and we're happy to address any questions as needed there. All right, now I mentioned licensing a few times, and we're going to go through some of the license options now just for a high-level overview of which is which. The DSP-5 is the most common that we see, and this is just a permanent export. Most exports will fall under the DSP-5 scope. If it's leaving the country and probably not coming back, that's the DSP-5. That's what most exports are. But then you can see the other numbers, and I don't know how they choose these numbers because they seem a little random. The 73 would be a temporary export. You need to send something to a foreign country to get a service performed on a part, electron beam welding, shot peening, whatever. You have a partner outside of the country, but it's coming right back to you anyway. The U.S. is a little less concerned that kind of military or defense article is out of the country for a limited scope for a specific purpose as long as it's coming back to you. So the licensing burden would be a little easier for you. There's a separate bucket if you're dealing with classified defense articles. A lot of people are just not dealing with classified articles, so I won't get into too many details with DSP-85. And then DSP-61, that for whatever reason I've seen a lot of lately, is a temporary import. Say you're the service provider and you have to do the welding or the coating or some kind of metal manipulation on a piece and then send it back out to a foreign customer. You don't want it to get stuck in the United States, so if you arrange for a temporary import license before you even bring it into the country, that's going to make things smoother when you have to get it back out. And we've seen things kind of get stuck if the temporary import license wasn't properly done ahead of time or wasn't done at all, frankly. Then it becomes a regular export, and it can be tricky. So if you know that's going to happen, you want to evaluate whether the temporary import license is something you want to have in your pocket before it even comes in. And again, there's a link there if you want to go explore what each of those would cover and the process for each of them. So, as I mentioned, the default for you should be if my product is controlled under the ITAR, it's on the USML or otherwise an ITAR product or service or technology, a license will be required unless there is an exemption available to you. There are a few that are useful and strategic in terms of allied nations or specific projects such as UK and Australia and Canada and NATO. No surprise that those are friendly countries, at least until the administration changes something. And there are a couple things for repair hardware and things like that you can kind of wiggle your way into, if appropriate, for your particular fact pattern. All these licenses, though, are pretty narrow, and the record-keeping requirement to use them is sometimes so onerous that people we've experienced would just rather seek the license, get their license on paper, and worry less about keeping track of everything that's being exported under an exemption if they just go ahead and get the license anyway. So there are options to explore, a little limited and a little burdensome in terms of keeping track of everything, but they are there. And when they are useful, they are very useful, but it doesn't apply to everybody. And like I mentioned before, sometimes you find a violation through your own audit or just it falls into your lap. You weren't really looking for it, but someone flags it. There is a process to voluntarily disclose that violation. And the State Department highly encourages you to do so, because frankly, if they find out the violation before you tell them about it, they're going to be a lot less friendly and a lot less lenient in terms of penalty and enforcement and any kind of structural administrative controls they may throw on you. So generally speaking, and in most scenarios, we would recommend the voluntary disclosure. There are a few exceptions where it may not be necessarily the best course, but there is value to the disclosure. It's probably going to bring the penalty numbers, the dollars, quite a bit lower, and in some cases to zero. But it does take some internal work, whether through outside counsel helping out or just someone internally leading the charge. You want to figure out whether it would have been an authorized transaction if we had just sought a license in the first place. That would help the State Department figuring out the root cause, hearing about what corrective actions you've implemented since, the strength of your compliance program, showing training records and training logs and things like that, are all going to help mitigate the damage. So pulling all that information together and crafting a helpful story for yourself is an important part of the voluntary disclosure process. In terms of the penalties that I mentioned, the State Department has authority under the statute, the AECA. 3 types of categories. I hope you're not dealing with the third, but the first 2 are administrative and civil. And the penalties can be very steep, and usually one fact pattern has multiple penalties, so that per violation number can multiply very quickly. So one export could have had 3 or 4 violations kind of packed in the related facts. And if there were multiple shipments or multiple transmissions or every day someone had access to something online was a violation. It can get nasty. Usually the government doesn't drop $100 million penalties on everybody, but they do occasionally, and usually big companies that have a widespread failure of a compliance program. Smaller companies, our penalties are scaled a little bit, but we still see small companies get some whoppers of penalties brought down. And if in unusual circumstances, if someone is caught knowingly and willfully violating the ITAR, you can subject yourself as a company and as an individual to criminal violations, including jail time and steeper financial penalties. So it's a high bar to get over, but companies can get caught with the what you would call the smoking gun type emails or letters that say, yeah, we know it's going to violate export controls, but we have to make this sale. And you'd be shocked at some of the stuff people put in writing. If the government finds that, I mean, it's hard to come back from that. So we are seeing more and more criminal violations come down. The Department of Justice gets involved, and they have a policy where they're trying to hold individuals accountable as opposed to the corporations themselves. So it's very important your operation and your organization is aware of these things, and that everyone knows what compliance really means and how serious these can be. All right. And my last slide, and we'll get through this, and we'll open up a little Q&A, and we'll have plenty of time before our 2 o'clock end comes around. DDTC has a guidance webpage. They call it the Essentials for Developing an Effective ITAR Compliance Program. And it lays out a couple of the key sections that it is expecting to see. And I'll go through them one by one here because they are worth hitting, even though you can all read them. The organizational structure is always an important emphasis for enforcement agents. They want to see someone in the compliance function that has access to leadership and has the avenue to talk to a CEO or CFO or CCO or whatever kind of leader within the company is appropriate for size and business to make sure the support is there. And that ties into the second one. There's a corporate commitment to getting this right. You want some policies in the company books. You want your leaders communicating the importance of export compliance, a statement on an internal website, a periodic refresher email to the whole staff. Those kind of things are helpful to show the corporate commitment. How you're tracking your ITAR data and your product. How have you classified your entire product line? Do you have 100 part numbers? Do you have 10,000 part numbers? How do you know what's what? Have you gone through that classification exercise? Are you tracking it electronically or on paper? And who has the latest version, or does everyone have the latest version of that kind of information? How are you assessing where your products are going after they leave your business in terms of, are they going to be re-exported or retransferred? You should have enough due diligence done to know exactly where that thing's going to go, whether it's electronic or technical data or the physical product. Doing that ahead of time and documenting it is an important part of the compliance program that the government's going to be asking about. Understanding prohibited recipients and prohibited parties and prohibited uses. Every transaction should pass through that loop of the analysis. Is this going to a prohibited party or a sanctioned party that's listed as problematic. There's software that runs through that. There's free options and paid options and a variety of bells and whistles. But that's an important step. If you get asked about something and you didn't do a customer screen, it's not going to look good. That should be baked into your compliance program, and your people should be trained to know how to do it. Then that kind of goes into record keeping as well, knowing what customer has received what products and what USML categories, in the case of EAR shipments, what ECCNs, how many they've gotten, etc. If you have a license, for example, that allows 20 exports up to $200,000 worth of value to this particular customer over 2 years, if that's how it happens to be structured, someone needs to be kind of deducting price and quantities from your license allowance, and if you go over it, there's an argument that you violated your license, and that would be an unauthorized export. And then internal monitoring and auditing too, I would put in there. Who's checking other people? How are you ensuring that it's working? You could do all the training in the world, but if you don't, follow the process and see where the gaps are, it's a continually evolving process that needs to be taken care of. And having that in the program and the structure for how the internal process will be monitored and evaluated and improved is expected. Again, you'll see how a lot of these are so related. The training logs and the training content and substance are huge. An empty file with 0 training speaks volumes, and you can have 12 trainings, once a month, 12 trainings a year, and it's good. Having 0 in your training log is bad. And maybe you probably don't need monthly training once everybody's up to speed, but being able to document that it happened and that it's working are two interrelated and important things. And then violations and penalties. Everybody should be aware of what a violation looks like and what the penalties are to impress the seriousness of getting this wrong. And this is a company-by-company assessment, are there punishments that would be appropriate for someone really screwing it up? Conversely, are there incentives for people that are really getting it right and driving a good culture in terms of compliance? Are you rewarding that kind of behavior? So I believe that's my last slide here. So as I said, we were hoping to give you a preliminary, high-level, quick and dirty view of the ITAR, and with future webinars, we'll get into more details and specifics of the various nuances. But I think we'll hand it back to Melissa for a couple Q&As where I'm happy to stick around a little while and go through a few questions.
Great. Thanks, Alfredo. Appreciate you, as always, sharing your great insights. Operator, could you remind everyone how they can get themselves into the audio queue for a question? I believe it's *1 if folks are looking to enter into the queue. Operator?
Yes, if you'd like to ask a question, please press *1 and record your first and last name clearly when prompted. Your name is required to introduce your question. Once again, if you have a question, please press *1. One moment while we wait for the first one.
And Alfredo, we don't have any others in the queue, but I have a quick question. I'm curious, in all the work that you've done with clients on ITAR-related matters, are there particular questions that seem to come up over and over again that might be worth highlighting?
Let me see.
I know it's a very general question.
Yeah, a lot of what I get is, do I have to classify every single product that we make? And, the conservative lawyer answer to that is probably yes. If there are logical groupings of product lines that are so obviously all the same category, then maybe you can make the business risk judgment on not going part number by part number and assigning a particular category, whether it's under the USML categories or the CCL categories for the EAR. You have a particular widget that you know is going to be XYZ every time, regardless of the design tweak. Then there's probably low risk. But you should have some kind of internal code to know this family of parts has been assessed, and our operating assumption is that they're going to be classification number XYZ, just to have some documentation that you thought about it, you made a decision, it was reasonable. It may not be right, but you would have some documentation should the government ever come asking questions that you didn't ignore it, you weren't trying to cheap out, you gave it some thought, and this was your reasonable answer.
Great, thanks. And we did have a couple come in over the queue, so I'll read those out. First is, how would we determine if a U.S. citizen could be considered foreign based on their company location? What if the company has multiple locations?
Could you read that again?
Sure. How would we determine if a U.S. citizen could be considered foreign based on their company location? I think this is going back to the deemed exports issue of...
Right. Depending on the corporate structure, shell game type thing, it can be complicated. The default starting point would probably be their direct employer's country of organization. It would be tricky if they are an employee of, say, a parent company, but really doing work on behalf of another company in yet another foreign country. That can start getting complicated. But for purposes of your first ITAR control stop, you're going to probably need a license regardless of whether they're operating under country A or country B. The tricky part would just be getting the right information down in your export license.
Okay, thanks. Let's check. Operator, do we have any questions come in?
Yes, we do.
The audio queue.
The first one is from Fran Thornton. Your line is now open.
Go. So I had a question. Can a U.S. citizen share technical data with a coworker who is also a U.S. citizen, but both of them are in a foreign country?
I'm assuming, Fran, that they're both working for a U.S. company, and let's say they're on a business trip together, visiting a foreign trade show or a foreign customer or whatever kind of international travel.
Correct.
Right. I can't give you a strong yes without the facts, but that comes up at conferences all the time, and I get slightly wavering responses from government agents that say it's probably not an export or a re-export because it's really not going to any kind of foreign entity at all, except that it's happening on foreign soil.
Right.
Though it would be a little bit of a scenario-based assessment, but there is an opening to consider that a non-export, but it would be a very narrow opening, and if the facts line up, you may be clear there.
Okay, thank you.
And operator, we'll take the next question in queue.
Sure. It's from Bill Berger. Your line is now open. Once again, Bill Berger, your line is now open. Please check your mute button.
Hi, Alfredo. Thank you very much for this conference. In the past, you had done some consulting for us, and I think you had used the term catch and release on USML about how they'll open everything, they'll try to pull everything in and then start releasing stuff. I found some categories more recently that I wondered, does the order matter? Like in particular, you might find something that I have a piece of equipment that is called out, an electric motor, very specific requirements that we don't meet, but then there's like at the very end of a clause, all parts associated. Do I then get captured back in, or the fact that I haven't met, if they speak of a particular product and I don't meet that criteria, am I in the clear, or do I get captured back again if they put all products, all parts, spares, that type of stuff?
Right. Good to hear from you, Bill. And let me take this opportunity to explain a little bit of the catch and release term. And I didn't get into it because eyes tend to glaze over when this comes up. But there is some USML categories under the ITAR have some language that will sound something like any part specially designed for this particular application. And then specially designed has its own definition that is structured. It was recently rewritten in 2013 to and for export control purposes. That's very recent. Where an item that's not specifically listed on the ITAR may be caught by a relatively broad definition, and then there's about 5 or 6 ways to kind of release yourself from the definition. And chances are you would get caught by the broad definition, and then it's a different story as to how to get out of it. For the most part, if the USML definition says such and such motor application, and later on it says and any parts related thereto, or however it's written, that would be enough to catch you in there. Really, the release part or the exceptions would be the critical part of that analysis, and you would have to qualify for those. So the default assumption, and we could always catch up offline, is whether you can be released based on the 5 or 6 release points.
Okay. So I guess it really in a reverse term, then they could actually kind of have a release and then catch you back again.
In a way, yeah. I don't want to confuse people there.
All right, sorry, I don't. Okay.
The catch and release concept, and I'm happy to explain that to anyone again offline as well. But it can be very tricky because there are a bunch of subparts within a particular USML category, and they tend, subpart A tends to be the higher level or higher order part, and then B and C and D and E and F tend to get more granular and more granular. So finding your place there, and then figuring out whether the specially designed definition even applies to that particular type of section. And at the moment it is USML category specific. Not every category engages that catch and release definition as part of the export control reform rolling implementation.
All right, thank you.
Got it.
And operator, is anyone else in the queue?
Yes, we do have another question from Adam Siegel. Your line is now open.
Hello, hi. I just had a quick question in reference if there are any specific guidelines when it comes to in reference of employees having smartphones on a premises where you're manufacturing ITAR-related components.
That's not there's nothing in the regs about that. It tends to become a business risk appetite type of decision. Some clients have a no cameras on campus period type policy, and some people just end up leaving their phones in their car. But as that becomes harder and harder for these types of devices, those kind of policies become more difficult to enforce. In terms of rules, those definitions we already hit in terms of release of technical data, deemed exports would still apply. It would just be how are things being released and how are things being inspected.
Okay, so there's no strict controls on, say, a company, not allowing employees to have smartphones in the building as long as they're, managed in an ethical manner.
Right, and a violation that an employee, is actively, acting mischievous with a phone would be a totally different type of scenario. Or, but any kind of foreign visitor should be, appropriately told that, photographs. If they're taking photographs, they need to understand the limits of where that photograph can go, if it's deemed to be enough to be a release of technical data. If it's just a photo of your reception desk, you're probably okay. But if it's, the whole site plan or specific features of a part or machinery, repair equipment, whatever, there's an analysis on, is that ITAR-controlled technical data or EAR-controlled technology? And if so, what are the licenses or license requirements for them? Maybe this particular individual has a license, but he brings this back to his company in country X and shows it around. That's a different story. So the analysis has to happen at some point. But in terms of specific rules on phones are allowed, phones are not allowed, there's nothing black and white.
Okay. And then just further kind of related to that would be storing photos on, say, like an iCloud.
Right, and that goes back into the ability to release technical data. There's a couple touch points on, are these photos technical data or technology under the EAR, which countries would need a license to get them, and then what kind of electronic controls are on a specific iCloud. And this isn't just for photos, this is for CAD, software files, you name it, anything electronic you could save if there is access available to that electronic space, whether through kind of backdoor access or blatant permissions. There's a little bit of debate as to what is constituting an export. Technically speaking, potential access is access under the ITAR, and that would be an unauthorized violation. We have a cybersecurity seminar coming up and a specific cloud-based export control seminar coming up later in the summer. So if that's a topic of interest, make sure you tune in for both of those.
Okay, thank you very much.
And Alfredo, we had another one come in over the queue, related subject, specifically asking to define what is technical data and if there's any reference material on the subject.
Absolutely. Let me go back to the technical data slide here, and you'll want to check out the full definition at 22 CFR 120.10. And I sense the flavor of your question is, okay, I'm seeing the words required for design, development, production, manufacture, et cetera, et cetera. What does the required piece mean? Could I design, develop, produce this without this particular piece of technical data? What does required really mean? And there is plenty of industry debate on that question. I know a few clients that have done kind of internal research memos themselves through their ITC groups on what the heck that actually means and kind of a flow chart for how to come out. And if you Google the question, you'll probably see some white papers from companies like Microsoft and things like that would have published kind of a thought piece on it, and we'll break down a few of those questions for you. Things like dimensions I tend to conservatively put those in the required piece, because what is an engineering drawing without dimensions? You know, you can't make anything. You need the dimension. There's an argument that an engineering drawing without any dimensions could still be a required piece, and then you start breaking all the elements of what you would consider data, you know, out of a blueprint or something. If you take subpart A away, what is it? You know, what is? So this is my way of stuttering through the answer that there is no clean definition for what technical data is besides the ITAR's definition. You also want to check out the EAR technology definition. And recently, the DDTC and the equivalent arm under the Department of Commerce had revamped some definitions last summer. And part of an alignment of definitions, they started making analogous definitions between the EAR and the ITAR, either virtually the same or very much more compatible. So there are some, there should be some publicly available slides or video replays from the Department of Commerce and Department of State. When these rules were coming out, they did some public webinars and public phone calls explaining some of the new definitions, and technical data was part of that discussion, and those would be a resource for you to explore.
Thanks, Alfredo. We had another question in the written queue. The scenario is the company had an ITAR product for which they had a prior violation and subsequently deemed it was no longer ITAR. The question is, do they need to voluntarily disclose?
It's a good question, and it's not an uncommon one, especially with the export control reform that started 4 years ago. Things that used to be ITAR may not be ITAR today. And if you happen to find an old transaction that was a violation of the ITAR at the time, even though it's not ITAR today, it does present a kind of silly question as to whether it would still be a violation. My answer is that there's a 5-year statute of limitations. So if the government were so inclined to go after a transaction that's less than 5 years old, they would look at the factual scenario on the date of the violation. And if it was an ITAR violation on that date, dating back to June 8th, 2012, at least for today, they would have legal standing to call that an ITAR violation. You would have a lot of mitigating factors in your favor. The fact that the State Department actively decided this was not worthy to be so protected under the ITAR that we moved it to the EAR is a very good fact. But in a technical sense, it would still be an ITAR violation. You would make the business cost-benefit decision as to, do we want to disclose this? Is it worth it, or do we run the risk of not disclosing it and keep moving forward with it as a non-ITAR product?
And operator, do we have any other folks in the queue?
Not at this time. If you would like to ask a question, please press star 1.
All right. Last one I see on the text box is whether ITAR data and controlled unclassified information are synonymous. And the answer is no, even though there are a lot of areas of overlap. The controlled unclassified information is defined under a different regulatory regime and more of a Department of Defense than under the NIST cybersecurity framework. Its own beast in terms of complying on the separate set of regs. So while on a Venn diagram there would be a lot of overlap of the circles, definitionally they are different and they are kind of managed and evaluated by different entities. So it would be risky to assume they mean the same thing all the time.
Great. Thank you so much, Alfredo. Do you have any closing thoughts for the group?
No, just encourage you to find the other seminars that are of interest. If you're brand new to export, try to get them all. My information is here on the last slide. I'll put it up again here. Any kind of one-off questions or bigger questions, we're available for help. We can have a chat off the clock for a while, see if there's a quick answer or point you to the right resources. But I'll be back on a few other webinars this summer, and hope you can join us for a few of those other ones.
Great. Thanks so much, Alfredo. Again, appreciate you sharing your valuable insights. And thanks, everyone, for joining us. We will talk to you next Tuesday, the 13th, for the introductory webinar on OFAC. Have a good afternoon.
Thanks, everybody.